All right. Hi, everybody. It's Friday, May 9th. So you know what that means? It's time for the conversation with WBZ's legal analyst, Katherine Loftus, about everything that happened in the Karen Reed trial this week. Hi, Katherine.
Hi, Kristina. Happy Friday.
Happy Friday. I apologize to our viewers. I'm a little under the weather, so my voice sounds a little crazy, but here we are. Okay, I want to go backwards. It's been a full week, if I do say so
That it
myself.
has.
So I want to go backwards because we record these for anybody who watches during the lunch break on Fridays. So when like all but 2 hours of testimony has happened.
Right.
And right before the lunch break, State Police Sergeant Yuri Buchanan read what seemed to be all of the text messages between Brian Higgins and Karen Reed for the entire month of January. More texts than we heard last year when Brian Higgins read them.
Right.
It was an hour and 10 minutes of reading text messages. And that's all that's happened for the last hour and 10 minutes. And the jury was, from my view, locked in, no longer taking notes, like this, watching the screen, reading the text. So my question for you is, what is the defense's strategy making him read these? They're not his texts. And
Yeah.
what impact does something like that have on the jury? Like the drama versus the hard evidence kind of stuff.
Well, you just said it yourself, the fact that during this, that the jurors are literally like notes down. I mean, listen, we're all human. Who doesn't love a little bit of drama, right? So, especially after having some dry witnesses, during the week, more technical stuff from some, it certainly spices it up a little bit. The question ultimately, I think, is what is the benefit to the defense in having these text messages read? And from those who remember trial one, they came in through Brian Higgins himself. It seems like there's a good chance that Brian Higgins doesn't get called by the Commonwealth. And therefore, that puts the defense into a little bit of a corner because in order to get ultimately to the request to have Judge Cannoni issue a third party culprit jury instruction, that the jury at the end of the trial, that the judge will instruct them on a bunch of things. And one of them the defense theoretically will ask for is that you can consider this, third party potential culprit. But in order to get that instruction, you have to develop enough evidence throughout the case, both in the Commonwealth's case in your cross-examination and in your own case in chief, if you put one on, to request that of the judge. So theoretically, there hasn't been much discussion really of Brian Higgins or Brian Albert up to this point. There's been sort of peripheral mentioning, from witnesses that he went into the house, so he was at the bar, things like that, but certainly not the focus as it was in trial number one. So it seems like this is the defense's way of introducing this idea of like potential scorned, lover, upset. Obviously, we're not there with the defense yet, but they're laying sort of the foundation for that. The difficult part, I think, is that it also does not look great for their client, right? Because there's two parties being involved in this, and you have the Commonwealth who's attempting to paint Karen Reed as and John O'Keefe's relationship as, not so happy behind the scenes. This actually substantiates the Commonwealth's claim that, there was other stuff going on. So it's a little, I think everybody feels the cringe, listening to them. They feel, sort of a little young and juvenile, I would say. But it's really interesting to see whether it's going to pay off for the defense, whether it helps or harms Karen.
And then on that note, you and I had spoken yesterday, and I want to make sure to this podcast about Yuri Buchanan's testimony about how, in your opinion, he did quite well on direct and then not very well on cross. What effect do these text messages have on his testimony? Like, is the jury going to remember the rest of his testimony? Or,
Right.
And then also, can you talk a little bit about kind of why you think he was not as great of a witness?
Sure. So I think today or Friday, he is doing a little bit better. He seems to have, but it seems to be biting his tongue a little bit more. But generally, when you have particularly police witnesses, you expect them to behave in a certain way, right? Number one, they're police officers. Number two, they're trained to testify, and they have experience doing it. But I think what happened in Yuri Buchanan's, the difference between his direct and cross is that he did very well on direct. He answered all the questions Brennan needed to, get out of him. He introduced the evidence. He really was being set up by the Commonwealth to essentially be sort of the surrogate for Michael Proctor, because not only was he there and he could independently testify to it, but that, the sort of subconscious inference that Attorney Brennan wants the jury to draw is that, okay, Michael, you can believe all these terrible things about Michael Proctor, but it actually didn't affect the investigation itself or the physical evidence. And you can rely on that because we have Sergeant Buchanan, who's this like credible, upstanding guy. And so he appeared that way on direct, and then on cross he immediately got defensive. I mean, right, right out the gate, he did it like there was no hesitation. He pushed back on nearly everything Alan Jackson said, and I think there's a lot of personal stuff that outside of this case that unfortunately does affect a lot of these witnesses, and it's but you can't bring that into the courtroom, and it felt like there was almost like a personal animus in answering the questions from Alan Jackson. So from the Commonwealth's perspective, I'm sure it was very frustrating to Attorney Brennan, because you put all this work into trying to establish something for it to kind of all fall apart. But it's an interesting observation you make, that you had all that, but now you have all these text messages, and it's like, the thing about juries is, think about Carrie Robbins. That's like long gone in juries' minds. So they're quick to move on to the next thing. And if you're the person introducing that themselves, like if I'm on the jury, I don't know. I think there's a fair amount of people who might be wondering, wait, is this supposed to be good for Karen? Why are her attorneys introducing it? We don't understand, because there hasn't really been any fingers pointed just yet. So we'll see.
And next, what I think is the big talker of the week, and you hinted at, it seems like Sergeant Buchanan's testimony has maybe solidified a theory that we've discussed, which is that the prosecution doesn't plan to call people who were some pretty key witnesses last time, like Michael Proctor, Brian Higgins, maybe Brian Albert. Do you still feel that way? And if so, what is that strategy?
I think, yeah, I feel even more strongly about it now. I didn't think that in the beginning. We talked a lot about it, that, Attorney Brennan didn't mention it in his opening and not getting ahead of it. So it's in terms of trial strategy, it's definitely risky, right? Because you run the risk of looking like you're hiding from it. But I think that, we talked a lot last year as a collective about how the Commonwealth really felt like in their case in chief, they were defending the third party claims instead of prosecuting their own case. So if you look at it through that lens, Hank Brennan is really only putting the witnesses in that he needs to prove the case, right? He has certain elements that need to be met for second degree murder, for the OUI manslaughter, and then leaving the scene. And if there's anybody outside of that is not necessary to the elements, and in theory is only going to be potentially harmful to the Commonwealth's case, why call them? I think Brennan's strategy, which it's risky, but it's smart, that he's basically calling the defense's bluff and saying, if you want to blame Brian Albert and Brian Higgins, put them on the stand. You can blame them yourself. Then they called or in my same thing with Michael Proctor. And then the way to rehabilitate those witnesses by Attorney Brennan is actually through cross-examination. So you get to ask all leading questions. Isn't it true you were investigated? Isn't it true that there was no finding of wrongdoing? Isn't it true you turned over this? And, like you take all the beneficial things to the Commonwealth and use them in cross-examination. So it's very, it's like advanced trial strategy. So I'm not surprised that this is what he teaches in law school. And it's risky, but it
Is that
might
what he
be.
teaches, trial strategy?
That's what he teaches. Yeah,
Oh,
trial advocacy. Yeah, yeah,
wow. Okay.
yeah.
Um, so you started explaining this, and I want you to explain it like even more simply because one of my top comments on social media lately is like, if the prosecution doesn't call these people, can't the defense? And the answer is yes, of course.
Yes,
But can you explain how things change if the defense calls these people as witnesses? These
yes.
people
So
being Dr. Brian Albert, Brian Higgins.
right. So when you call someone as your own witness, so if we talk about right now, it's the Commonwealth's case. So anybody the Commonwealth calls, that's your what's what we call direct examination. And direct examination, basically, in the simplest way, is asking narrative form questions. So, where were you this night? What happened next? Can you explain this? And so you can't guide the witness to the answer you want them to get to. That's direct. When the opposing party, which right now is defense, gets up, they get to cross-examine, and on cross-examination, you get to ask what's called leading questions. And leading questions are things like, and didn't you punch John when he walks in the house? Correct, those kinds of things. You basically, the answer to your question is your question. And so what will happen in theory is if the defense calls any of them or all three, they have to ask them narrative based questions. Now, what the goal will likely ultimately be is to have them declared as what we call adverse or hostile witnesses, which means that even though you're the party calling the witness, they're taking in a position that's adverse to your position. Now, I don't think it will be difficult to get there. However, you do have three trained police officer witnesses. So it's probably not as easy to get them declared hostile as maybe a civilian might be, because
They have to actually demonstrate that hostility in order to get them declared hostile,
that's
right?
right. And then you have to ask the judge, and the judge gets to decide if you've gone there yet. So and so even if they do, if they get them declared as hostile witnesses, and then they can cross-examine them. But like I said, then Brendan gets to get up and use that same kind of leading questions for everything, but lead them back to, you know, this idea that you were investigated for all these things. So all these things are true, but are you still an ATF agent? Have you been fired by the federal government? You're still working for them. So what does that tell the jury? That, okay, these guys have some problems, but everyone who's investigated them has let them keep their jobs. So that actually, I mean, it's pretty smart of Brennan to think that far ahead.
Right. And so I think that's why you're saying it's risky, right? Because if it works, it could have a huge payoff if the
Yeah,
defense calls these people. However, the defense could also not call these people and they could just be like ghosts whose names are hovering in this trial and the jury's
right.
wondering who they are.
I mean, I think so. If theoretically, no, they don't call anybody, Michael Proctor, Brian Albert, or Brian Higgins. I mean, I don't know that that's possible, because I don't know how then they get to the third party. And the problem from the defense perspective is that, so they have basically two defenses: third party culprit and Bowden. And they're sort of wrapped up together. They could have been separated if nobody put John in the house. So if Karen had not made statements that John went into the house, then I really think the Bowden defense, which would be going at Michael Proctor, going at, Gallagher for not getting the camera, for not writing a report, for them going into the house and not separating them. I mean, the inadequacies in the police investigation are so, it's in any other world, in any other criminal case, they'd be like a gift to a defense attorney, because how can you say, even if things point to Karen, how can you say that John didn't throw a glass at the back and it smashed and splattered back on him, and that's why then there's no actual evidence that she hit him, things like that? That's a viable argument if no one puts him in the house. But the problem is Karen now puts him in the house, so you take that argument really off of the table, which then leaves you with the need to establish something had to have happened in the house. And the police engaged in a cover up. So you really have to do these two things. So I think the defense has put themselves in a little bit of a pickle, allowing her to speak. I mean, I think in more ways than one. So I think they have to call Albert and Brian Higgins if they want to point the finger, because otherwise I don't think there'll be enough evidence in the Commonwealth's case that they'll be able to argue it in closing.
I have a couple more topics for you, which I
Sure.
think a little quicker. So you mentioned that, in your opinion, the difference in this case is that Brennan is playing less defense,
Yeah.
and more offense. There is
Yeah.
one area he has undoubtedly played a lot of defense on, and that's the alleged 227 Google search of Jen McCabe.
Yeah.
There's been days of testimony on that point alone, including this week when Jessica Hyde was on the stand for, I think, 2 days. So at this point in the game, again, we have not had the defense's witness yet. But at this point in the game, if you're a juror, what are you thinking about that Google search?
I mean, I'm thinking you have two independent witnesses who come to the same conclusion. They both seem to be pretty qualified, their background, their experience. There was an attempt to, poke holes in their stories, but it seems like ultimately they both came to the same conclusion, independent of one another, that the 227 search didn't happen and that it was 623 and 624. So I think there will likely be an expectation that you'll have, the same caliber of expertise testifying on the defense side. I don't know if that's how the jury is going to find about Richard Green. I mean, certainly he's qualified, and that's not to diminish his background at all, but in terms of, who was looking to who for guidance, we know that Richard Green was seeking Ann Whiffen and Celebrite's guidance on how to interpret. So when a jury is looking at, okay, two over here independent of each other say it doesn't happen, he says it does happen, but before he determined that, he was looking to them for help. The weighing of that is, I think Richard Green is hard to, throw the other ones off balance.
Understandable. All right, 2 more points. One of which is, if, again, this is still the Commonwealth's case, if Hank Brennan is on offense right now, which he is, what elements are still left? Like, what types of witnesses are still needed? I mean, at least from my observations, I don't think there has been a witness yet of, like, here is how Carr met John.
I think that's the only. So for second degree murder, you need to show that Karen Reed caused the death of John O'Keefe, and then intended to do is 3 prongs. And the prong that the Commonwealth is going under is that she intended to do the act, which is the reversing of the vehicle, which a reasonable person would know could cause grievous bodily harm or death. So that's second degree murder. I don't know that he's anywhere near second degree murder, so I'm not sure that it's even is worth the time to evaluate, because I don't know that he'll ever get there. The manslaughter, well, OUI, you basically have to prove 2 separate prongs, really, and then mush together. So you have the OUI, which is operation. So we know she operated the motor vehicle. She admits it, both in her statements, and she's on video. You have to prove public way, so that just means that you're not in a driveway or someplace else. You have to be on a road that's owned and operated by either the Commonwealth of Massachusetts or the town that you are operating in, and then intoxication. And so I think the intoxication element has been met. But aside from, there's the back and forth about the blood alcohol level, but there's multiple videos of her drinking. She admits that she shouldn't, she wouldn't have gotten on the expressway. So I think intoxication is pretty clear. The next 2 elements are, you have to show that you're operating in a reckless or negligent manner, which I think can be met because basically OUI is per se negligence, right? So, and so then the last prong is that you caused the death of John O'Keefe. So that's the only prong. I think they're only 1 out of the 5 elements. I think he's got the 4. He has to prove that she caused with her vehicle those injuries. And so that's why I think we're going to see all the injury presentation on the back end. So we're going to have aperture, we're going to have the Lexus data, we're going to have the, I don't know if we're going to have the ME and the neurosurgeon about the brain injury, and probably the state police crime lab talking about the microscopic pieces found in his sweater. So he's pretty close. He's pretty
Yeah,
close. It
that seemed,
depends on how that evidence comes in.
right. It seemed during the last trial like that was probably the hardest element to prove.
Yeah, and it was very unclear. And so you have, you had somebody like Trooper Paul. We didn't have, watching it, we didn't have a real explanation of, it was. I can imagine on the last trial how difficult it was for a juror because, just watching the trial, it was very confusing about, okay, cell key cycles and shifts and this and that, and the data was not presented clearly.
Like
So,
what happened?
right, right. Like what is the actual theory?
Yeah.
So I expect from Dr. Welcher, who's with Aperture, that he's going to explain
Okay.
what the Commonwealth actually thinks happened.
Okay. My final question for you is what I think will be a quick topic. We've talked a lot about Karen Reid's statements, her media interviews, etc. She made a comment this week outside of court after the Jen McCabe clip played, in which she basically said it's me or Jen McCabe. That it was out of context, and some comment like you'll see the real context. This is another question I've gotten a lot. My understanding is that the prosecution can play those clips because they are statements of an opposing party. Is there a world in which the defense can also play clips of Karen Reid? And if not, what could she mean?
So generally no, unless you can make an argument to the judge that somehow it, under the, I suppose you can make an argument under the doctrine of completeness, but the problem is that you can't introduce your own self-serving statements, right? You can't say, okay, this is what I said and it benefits me. And so, I mean, the only thing I could think that to mean was that she would potentially testify, and in reality, I think that's basically never going to happen. But the interesting thing, I've gotten the same question, and if you think about it, in some ways, even if let's say for argument's sake they could play the rest of the media, the clips, right? Maybe they say they do, just for argument's sake. Does that actually help you when you are speaking to the media and then you feel like it's so taken out of context that so now they're really on the defense. They're trying to explain, wait, that's not what she meant. Wait, that's not what she said. But you have your client sitting right here next to you. Why do you have to play media clips to explain it? Just put her on the stand, so I just think I think the clips are bad for her overall, and I don't think that there's a way for the defense to remedy them.
All right, I think that's all I have this week. This is a good one though. We
Hey,
appreciate you.
you let me go. I'll just talk and talk.
No,
Every time I said it's going to be short,
yeah.
probably not.
No, but there's just like a lot of stuff happening this week that I think needs a lot of legal explanation. So that's
Yeah,
why I think that we have you.
yeah. Happy to be here.
Actually, this should be a good time as a heads up for our viewers. I won't be here next Friday, so we might have to do this on Thursday.
Okay.
We might lose a day of testimony to talk about. And that's it.
Okay. That sounds
Thanks.
great.
All right.
All right. Have a nice weekend, everyone.
Bye.